Hi, I'm Lee Coleman. I'm an attorney at Hughes and Coleman Law Firm, and one of the issues that comes up when people call us and they have had a loved one injured in a nursing home or unfortunately all too often has died as a result of injuries in a nursing home is how much time do we have to file a lawsuit? Well, Kentucky has very short time limits. Generally, Kentucky, it's 1 year. It gets very complicated from that basic starting premise of 1 year time limit called a statute of limitations, and that's just how much time you have from the injury to file the lawsuit. So a quick legal lesson, try not to get too complicated, but there's a big difference in the time limit if in the state of Kentucky if someone has died as a result of the injuries or if they're still alive. So let's start if they're still alive. Well, if they're still alive, you have 1 year from the date of the injury or the date on which someone knew or had reason to believe they were injured. It gets a little bit more complicated if the person's in a coma and doesn't have a guardian appointed for them. So there are different things that the lawyer can use to try to get more time, because sometimes we'll be contacted by somebody and it's been 13 months since the injury occurred. Well, then we're trying to figure out, is there something that gets us a little bit more time? And maybe we can get a little bit more time because the person didn't even know they were injured. The nursing home facility may have covered it up, not disclosed it to anybody. Or it could be that the loved one was in a coma and didn't have anybody appointed as their legal guardian, and that might get some more time. So it really gets to be a complicated question, but because it's 1 year, then you just need to assume that 1 year early, from the first sign of injury, and get to a lawyer quickly so that they can start, pardon me, so that they can start getting the records to figure out how much time do you really have. Now, the second thing is that if your loved one has died, then Kentucky has a rule saying you have 1 year after a legal administrator is appointed by a probate court, by a probate judge, to be the legal administrator of the estate, either an executor or legal administrator. It's the same job, just different title if there's a will or no will. But from the date the judge appoints the legal administrator, there's an order that'll have a date on it, then there's 1 year from that date to file the lawsuit, or else it's too late. Now, there's more to it than that. In other words, and by that I mean the legal administrator had to have been appointed within 1 year from the date of death. And as long as the legal administrator was appointed within 1 year from the day of death, then the 1 year starts going from the date of the appointment. So it's a little bit complicated, but a lawyer can figure it out. If you get to them in time, they can look at the facts and figure out how much time you have. I'd invite your comments if you've had a bad situation or had a case that a lawyer turned down because there wasn't enough time or because of the time limit. We'd invite your comments so we can share them with everyone else out there who has a similar situation. Thank you. Have a good day.